Good morning, everybody, on this rainy, somewhat dismal St. Louis day, but we had a beautiful day yesterday, so we can't really complain too much. My name is Layla Sadat. I'm the director of the Whitney R. Harris World Law Institute and the Oberschelt Professor of Law at Washington University School of Law. Thank you so much for being here today to share this very special event. Distinguished guests, members of the law school community, students, colleagues, friends, it's my great honor and privilege to introduce our speaker today and to say a few words about her. Before briefly outlining her biography, however, I would be remiss not to thank Professor Karen Tokars, who's just walking in, for, as always, putting together a fabulous public interest law and policy speaker series and allowing the Harris Institute to collaborate with her and the staff of the law school for their help in putting together today's event. Thank you, Karen. And thank you, too, to the Harris Institute staff for their hard work in putting this event together. And finally, last but not least, let me thank Anna Harris, whose generosity, along with that of her late husband, Whitney Harris, has made today's lecture possible. Thank you, Anna. Yeah. Fatou Bensouda is the deputy prosecutor and the leading candidate for chief prosecutor, at least those of us who follow these things closely think that, at the International Criminal Court in The Hague. This court, which as of yesterday now has 118 states members, although not one more, but not the United States, is charged with bringing to justice those individuals who have allegedly committed the most serious crimes under international law. The court's jurisdiction includes genocide, crimes against humanity, and war crimes, and perhaps in the future might include the crime of aggression as well. I know that Prosecutor Bensouda will talk more about the cases that her court is currently addressing, and I will leave that discussion up to her. But what I suspect she will not discuss is the important role that the Office of the Prosecutor itself and Madam Prosecutor herself play in the struggle to address the continuing problem of impunity for international crimes. The ICC has many, many organs and subsidiary organs. It has a judicial body. It has a registry. It has the Office of the Prosecutor. It has a trust fund for victims, an assembly of states parties that oversees the court's operation, a defense unit, a victims and witnesses unit, et cetera, et cetera. And each of these play an important role in bringing justice, and in the case of the Victims Trust Fund, restorative justice to afflicted communities. But in all the complexity, I think it's without a doubt that it's the Office of the Prosecutor itself that's the engine of international justice, because it's the prosecutor's office that has to decide which cases to bring and which cases not to bring, because maybe there's no jurisdiction, the facts can't be proved, or there's some other reason that the court shouldn't be going forward. As of May 2011, according to ICC statistics available on the website, OTP had received more than 9,000 communications from parties alleging crimes within the jurisdiction of the court. About half of those were manifestly unfounded, according to OTP, but that leaves an awful lot of cases to wade through. It is the prosecutor who's going to listen to the heartrending stories of victims, interview the victims, and start building cases. It's the prosecutor who presents the case to the court. In today's modern international criminal justice system, it is the prosecutor who pleads on behalf of imperiled civilization, just as at Nuremberg, which was Whitney Harris's tribunal, it was the prosecutor who pled before the bar of civilization itself. And perhaps it's also the prosecutors who, because they're the most public face of the court, also receive the most public criticism about the court. Attacked for moving too quickly in the Libya situation, too slowly in the Sudanese situation, having arrest warrants that are too fast or too slow, having indictments that are too broad or too narrow, expending too much money, expending not enough money. I think the list just goes on and on and on. And against this kind of criticism and these odds, the prosecutors need strength, stamina, courage, integrity, and a firm belief in what they're doing, that they're making a difference. They have to be strong enough to stand up for their victims in court and courageous enough to do so even when their physical safety is threatened, which happens quite often. They must be persons of great stamina to be able to do this hour after hour, day after day, year after year, and to conduct field investigations at mass atrocity sites, poking through the lifeless remains of what used to be human beings whose lives were shattered by the perpetration of atrocities against them. And moreover, they have to accomplish all of this while exhibiting extraordinary integrity so that the interest of their true client, the interest of justice for whom they plead, is furthered and not hampered by their cases. They can only accomplish this if they put their heart into their work, and yet they know that sometimes their heart's going to be broken because good cases that they've worked hard on are going to result in acquittals, not in convictions, because justice has to be fair. And that means that sometimes acquittals need to be given out. And finally, they have to combine all these qualities of character and soul, if you like, with technical and legal craftsmanship of the highest order so that their advocacy can turn the heart-rending tales of victims into winning complex and sophisticated cases. So forgive me for going on for so long, but you can see that given this list of qualities, and in particular, we can see why Prosecutor Bensouda was granted and awarded on Tuesday evening the World Peace Through Law Award by the Whitney Harris World Law Institute. This award is bestowed on a group of elite international leaders. This award is bestowed to those who by their work and writings have considerably advanced the rule of law and thereby contributed to world and peace. Established in 2006 through a generous gift from Whitney and Anna Harris, the award recognizes individuals who have achieved great distinction in the field of international law. In her role as Deputy Prosecutor for the International Criminal Court, and before that as a senior legal advisor at the Rwanda Tribunal, Prosecutor Bensouda has brought commitment and integrity and professionalism to the task of ending impunity for the perpetrators of atrocity crimes. She also, prior to her service as an international prosecutor, had a long and distinguished career in both private practice and in government service, serving as Attorney General of the Gambia, her home country. It also seemed appropriate for Fatou Bensouda to be the first woman to be honored with this award, especially this week as we celebrate the 140th anniversary of Phoebe Cousins. And she was a pioneer in the law 140 years ago in the state of Missouri, just as Fatou Bensouda is a pioneer in the law in her home state of the Gambia and now playing on an international stage. Her work is an inspiration to women everywhere, and especially women in Africa, who are so often the victims of the atrocities that the court work is destined to prevent. When she stands in court pleading on behalf of her victims, no listener can be insensible to her sincerity, her authenticity, her strength, and her integrity. And finally, it's a great personal pleasure for me to welcome Fatou Bensouda to Washington University, as she has become a great friend and supporter of both the Institute, Whitney Harris, and myself, and I consider myself very fortunate. She has attended the International Humanitarian Law Dialogues for several years that the Harris Institute is proud to co-sponsor, and many of you have already had the opportunity to hear her speak during her 2 days at the law school. We've kept her very, very busy. I think she's become a full-fledged member of the Washington University community, and please join me now in thanking her, in recognizing her award, and in welcoming her to the podium.
Professor Sadat, Professor Karen, Anna, thank you very much. Thank you for this opportunity to be here. And distinguished ladies and gentlemen, students, thank you for being here. And thank you to the Whitney R. Harris World Law Institute for this very kind invitation. I would like today to share with you some reflections in relation to the International Criminal Court, a unique institution which I have the privilege to serve as the Deputy Prosecutor. I will try to look back at some historical developments, and I will try to discuss also current activities and challenges for the office. And finally, I would like to look ahead and take this opportunity to present to you some ideas to deal with today's global problems, and more importantly, to prevent those problems from recurring. The ICC, as Leila has just mentioned, was created in 1998 by the Rome Statute. The statute defines the mission of the Office of the Prosecutor, for which I have the privilege of serving. And that mission is to put an end to impunity for the most serious crimes of concern to the international community: the crime of genocide, crimes against humanity, and war crimes. And by doing that, to contribute to the prevention of these crimes. The Office of the Prosecutor itself is part of this new system of international justice that has been created by the statute. Today, there are 118 states parties to the Rome Statute. In fact, the latest number was just yesterday. Maldives has signed and ratified the Rome Statute right after Philippines. And all of these states who have signed and ratified the Rome Statute have committed to prevent and punish massive crimes using the rule of law to protect their own citizens. This institute, this ICC, is a 21st century institution. And we cannot overemphasize the role of institutions. The world, we know, is facing different international problems, which in turn require regulation. We talk of climate change. We talk of international trade, international finances, and international crimes. And the two areas that we see progress are those where international institutions were created to manage the challenges. And here I'm talking about international trade as well as massive crimes. The World Trade Organization, as we know, and the International Criminal Court. 60 years ago, with the Nuremberg trials, for the first time, those who committed massive crimes were held accountable before the international community. For the first time, the victors of justice chose the law to define responsibilities. And in the words of the Nuremberg prosecutor, Justice Robert Jackson, he said, and I'll quote him, that 4 great nations, flushed with victory and stung with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of law is one of the most significant tributes that power has ever paid to reason. Nuremberg was a landmark, we know, but the world was not ready to transform this landmark into a lasting solution. And in the end, the world would witness and wait for almost half a century and witness again 2 genocides, first in the former Yugoslavia and secondly in Rwanda, before the United Nations Security Council decided to create the International Criminal Tribunal for former Yugoslavia and then the International Criminal Tribunal for Rwanda, respectively, thus connecting again peace and international justice. The ad hoc tribunals paved the way, therefore, for the decision of the international community to establish a permanent international court to avoid, we all said, the repetition of the past experiences. A court that was built on decades of when the law had failed to prevent massive crimes. Yes, the ICC was created in 1998 in Rome during the United Nations Diplomatic Conference of Plenipotentiaries on the establishment of an international criminal court and added an independent and permanent justice component to the world's efforts to achieve peace and security. My friend, Professor Sadat, was one of the delegates, as we know, to that conference and witnessed the creation of the International Criminal Court. The UN Secretary General, Ban Ki-moon, said in 2007, again, I will quote him, please allow me, that the rule of law is a fundamental principle on which the United Nations was established. He continues, international criminal justice, a concept that is based on the premise that the achievement of justice provides a firmer foundation for lasting peace, has become a defining aspect of the work of the organization, referring to the United Nations, unquote. The International Criminal Court Rome Statute offers a solution, a new instrument of peace, creating global governance without a global government, but with the international law and courts. The court was built as a matter of realism, as a form of protection. That is the main point. Accountability and the rule of law provide the framework to protect individuals and nations from massive atrocities and to manage conflicts. Citizens of the states parties to the Rome Statute are under the protection of the International Criminal Court. And the legal framework established by the Rome Statute consolidates a new trend. And that trend is no more impunity for alleged perpetrators of massive crimes. No more golden exiles for the likes of Idi Amin Dada, for the likes of General Pinochet. In the Rome Statute community, leaders using massive violence, either to gain power or to retain that power, will be held accountable. One of the main principles of the Rome Statute is that states commit to investigate and prosecute and prevent massive crimes when perpetrated within their own jurisdiction. States have accepted that, should they fail to investigate and prosecute, the International Criminal Court could independently decide to step in. Under the principle of complementarity, proceedings before the ICC as a court of last resort should remain an exception to the norm. The primary responsibility for the prosecution of gravest crimes lies within the national jurisdictions. Under the Rome Statute, the statute creating ICC, states parties, moreover, have committed to cooperate with the court whenever and wherever the court decides to act. The court can therefore rely on the cooperation of the police of all states parties to implement its decisions. And this is not just an abstraction. Cooperation with the fact is a reality, is a fact. The Democratic Republic of Congo surrendered 3 of their nationals to the International Criminal Court. The Belgian police implemented in 1 day an arrest warrant against Jean-Pierre Bemba, a former vice president of the Democratic Republic of Congo. And France, cooperating with Rwanda, which is not a state party as we know, did the same with regard to Calixte Mbarushimana, a leader of the Force Démocratique pour la Libération de Rwanda. Ladies and gentlemen, let me briefly explain how the Office of the Prosecutor conducts its activities in practice. As you know, the court's jurisdiction can be triggered in 3 manners. A state may refer a situation where massive crimes appear to have been committed to the prosecutor. The United Nations Security Council, also acting under Chapter 7 of its powers, can refer a situation to the prosecutor, or the prosecutor can initiate an investigation using his own initiative. It is important to note, however, that neither a state party referral nor a United Nations Security Council referral binds the prosecutor into opening an investigation into a situation. Under the Rome Statute, it is for the first time that a prosecutor of an international court is given the mandate to independently open investigations into situations. In the instance of Nuremberg, Tokyo, former Yugoslavia, and Rwanda tribunals, it's the states that selected the situations to investigate, or even the cases in the instance of the Special Tribunal for Lebanon. And on the basis of these criteria relating to jurisdiction, admissibility, and the interest of justice, the prosecutor of the ICC must determine whether there is a reasonable basis to initiate an investigation. These criteria apply irrespective of the manner in which the court's jurisdiction was triggered. And with regard to jurisdiction, the Office of the Prosecutor assesses whether the alleged crimes are committed on the territory of a state party or by the national of a state party, whether these crimes have been committed after the entry into force of the Rome Statute, which was on the 1st of July 2002, or later, if the relevant state has ratified, and whether the alleged crimes fall within the subject matter jurisdiction of the court, which covers the crimes against humanity, genocide, and war crimes. This jurisdictional limitation is the main reason why the Office of the Prosecutor cannot investigate or monitor situations in non-state parties, such as Syria or in Bahrain. And this can only be repaired by a referral from the United Nations Security Council or through acceptance of jurisdiction by that state concerned, such as what was done in the case of Côte d'Ivoire. Côte d'Ivoire is not a state party to the Rome Statute, but has accepted jurisdiction, made a declaration accepting the jurisdiction of the ICC. As a result, we have sought authorization from the chamber, and we should be investigating Côte d'Ivoire once that authorization has been given. So naturally also, a state may decide to join the ICC. And with regard to admissibility, the office has a duty not to investigate when there are genuine national investigations or prosecutions. And this is pursuant to the principle of complementarity, which I have mentioned before. The statute also requires that the crimes reach a threshold of gravity. For instance, the Office of the Prosecutor conducted preliminary examinations of alleged crimes committed in Iraq by nationals of 25 states parties involved in the military operation there. We found cases of willful killings and torture that were committed, but we found that they were committed not as a part of a plan or a policy or as a part of a large-scale commission. And these findings, of course, were in respect of those states that are already part of the ICC system, those states that have signed and ratified. And because of that, we could not open an investigation because the cases did not reach the gravity threshold in respect of those countries. And in addition, we also found that these particular states were already conducting domestic investigations and prosecutions. If you recall, I just said that if states are genuinely doing that, the ICC will take a backseat. And finally, in accordance with the statute, the prosecutor should not proceed with an investigation or prosecution if it is not in the interest of justice. It would, however, be exceptional to decide that an investigation could not be in the interest of justice and the victims. And I should stress here that the interest of justice must not be confused with the interest of peace and security, which falls within the mandate of other institutions, such as the United Nations Security Council. In fact, the statute provides in Article 16 that no investigation or prosecution may be commenced or proceeded with if the Security Council, in a resolution adopted under Chapter 7 of the United Nations Charter, thus in the interest of peace and security, has requested the court to that effect. The court and the Office of the Prosecutor itself are not involved, of course. We cannot be involved in political considerations. We have to respect scrupulously our legal limits. The prospects of peace negotiations is therefore not a factor that forms part of the office's determinations on the interest of justice or any other assessment of the court. Ladies and gentlemen, following the legal framework that I have just briefly described, the Office of the Prosecutor has opened investigations into the Democratic Republic of Congo, in Uganda, in Central African Republic, in Darfur, in Kenya, and in Libya. And additionally, the office has requested the pretrial chamber, I just mentioned this, for authorization to start investigations into the Côte d'Ivoire. Let me highlight just a little bit the situation of Libya. The Office of the Prosecutor initiated our investigations in Libya on the 3rd of March this year, 2011. And this followed a United Nations Security Council resolution unanimously referring the case of Libya to the court on the 26th of February, 2011. That was Resolution 1970. The adoption of this resolution, this 1970 resolution by consensus, was a unique moment, showing how the ICC now is part of the international landscape. And even the 5 non-state parties asked for the ICC's intervention to end impunity for those most responsible and to prevent further crimes. On the 16th of May, 2011, the prosecution requested arrest warrants for Muammar Gaddafi, his son Saif al-Islam, and the then head of the military intelligence, Abdallah al-Sanusi. And these requests for arrest warrants were for crimes against humanity of murder and political persecution that were allegedly committed on the territory of Libya. The pretrial chamber considered our request and issued the warrants on this basis on the 27th of June, 2011. The evidence that we had shows that Gaddafi's forces attacked unarmed civilians in their homes and in public places. They were shot whilst demonstrating with live ammunition. They used heavy weaponry against participants in funeral processions and placed snipers to kill those leaving mosques after prayers. Gaddafi, Saif al-Islam, and Abdallah al-Sanusi planned the crimes we found since the start of the Arab Spring in Tunisia. They committed the crimes with the goal of preserving Gaddafi's absolute authority, which we found also is enshrined in Libya's law. Gaddafi's orders are binding even for the Congress. It is a crime in itself to challenge the authority of Gaddafi. And he used this authority and relied on his inner circle to implement a systematic policy of suppressing any challenge to this authority. And Saif al-Islam, his son, acted as a de facto prime minister, was active in the recruitment of mercenaries and the financing of the repression. Al-Sanusi was Gaddafi's brother-in-law, we found, and the head of the military intelligence, and we found also that personally he commanded some of the attacks directly. The ICC has not requested the intervention of international forces. We have not requested them to be able to assist us to implement the arrest warrants. We have said continuously that the primary responsibility to execute the warrants lies with the territorial authorities. And the office has consistently made clear that respect for Resolution 1970 and the judge's decision cannot be the subject of negotiation. The office is consulting at the moment with the Prime Minister of the Libya Transitional Council, who has now promised full cooperation with the office in the implementation of the arrest warrants. But arrest in itself, arrest of the fugitives wanted by the ICC, remain the biggest test for the international community. The long-time outstanding arrest warrants for Omar al-Bashir, the president of Sudan, and against Joseph Kony, the leader of Uganda's Lord's Resistance Army, have now, I think, amply demonstrated the difficulties that we face. And it requires the collaborative efforts and the consistent approach of states and international organizations. These massive crimes that are committed require a careful plan. And certainty that these crimes will be investigated and prosecuted will modify the calculus for these criminals. It will deter the crimes, and it will protect the victims. As to the tangible question of whether arrest warrants negatively impact mediation efforts, I have already received a couple of questions in that regard. This I am submitting to you has not been empirically proven. In fact, in some of the previous cases, negotiations appear to have in fact been prompted by the requests and issuance of the arrest warrants. And in other cases, the prospects for negotiation was used as an excuse by those who allegedly committed the crimes to regain power or to commit new atrocities, and mediation efforts were manipulated by those leaders. Eventually, implementing the arrest warrants will be the most effective way, I am still submitting, to protect civilians under attack. Ladies and gentlemen, besides the investigations and trials, the office is also conducting preliminary examinations analyzing alleged crimes in Honduras, Republic of Korea, Afghanistan, and Nigeria. We are also checking if genuine national proceedings are being carried out in Guinea, in Colombia, and in Georgia, and we are also assessing the ad hoc declaration accepting jurisdiction by the court by Palestinian Authority and by the Palestinian Authority. And whereas the goal of the statute is to end impunity to contribute to the prevention of future crimes, the practice of the office has shown that the mere initiation of preliminary examination has a deterrent impact. And this impact will depend on the national and international support to the justice activities to end impunity. The office has a legal mandate. We do not have the flexibility to adjust to political considerations. These actors will have to factor in the court's activities. Guinea is a good example, I'll just mention. Shortly after we announced that we are concerned about the serious allegations surrounding the events of 28 September in Conakry, the Guinean Minister for Foreign Affairs traveled to the court and met with me. He described the events, and he also mentioned what measures were being taken at the national level to address the atrocities. And according to him, he said that Guinea was going to strive to ensure that justice prevails within the country in partnership with the concourse of the Office of the Prosecutor. And since then, we have been fielding certain missions to Guinea just to monitor what is going on, what is happening, and to see whether Guinea is doing its own national investigations. Another example is Colombia, where the prospect of the ICC attaining jurisdiction was mentioned by prosecutors repeatedly, by the courts, and even by legislators and members of the executive branch as a reason to make policy choices in implementing the justice and peace law, thus ensuring that the main perpetrators of crimes over there will be prosecuted. The ICC will only do a few cases, but each case that we do has to have an exponential impact. And this impact should reach beyond the confines of the courtroom. As described by Prosecutor Moreno Ocampo and also by the United Nations Secretary General Ban Ki-moon, they say that there is now, they call it a large shadow of the court. And this they are referring to the impact of the court or a single court ruling extending to 117 states and even to reach beyond this to non-states parties. It is affecting the behavior of governments and political leaders. And armies all over the world are adjusting their operational standards. Conflict managers and peace mediators are defining their strategy and at the same time taking into account the work of the court, of course respecting the legal limits. The world increasingly, I believe, is understanding the role of the court. Let me explain by just giving you a few examples, and I will be done because I think there will be a lot of questions probably. The investigation of the office in Libya, we believe, will make clear that attacks against civilians will constitute crimes against humanity and will not be tolerated. We also believe that the cases in Kenya will show that leaders cannot use violence to gain or to retain power. We think that a similar signal is expected to be sent when we finish our first trial, as I have mentioned already, that we're awaiting judgment. And in that first trial, Mr. Thomas Lubanga was charged with enlisting and conscripting children and using them to participate actively in hostilities. We're expecting the judgment, as I said, before the end of this year. But we think that already it has helped demobilization efforts, including in non-state parties such as Sri Lanka and Nepal. Our trial against Jean-Pierre Bemba, a former presidential opposition candidate in the DRC and also a former vice president, who was arrested for crimes occurring in the Central African Republic. There we are aiming to show that gender crimes will be prosecuted and that commanders have a responsibility to ensure that warfare is contained within the limits of the law, and that no leader, however connected, is above the law. And this, I believe, is the way forward. The shadow of the court is what really matters. Let me conclude, ladies and gentlemen. There is now a new international justice system. In Rome, states made a conscious decision to create a justice system that could stop or prevent rather than act after the events. New rules were created and other actors must adjust to these new rules that need to be implemented. And again, I'll quote Ban Ki-moon, allow me, I like quoting him. Ban Ki-moon said, and this he said as recent as the Kampala conference, the review conference of the ICC, which took place in Kampala last year. Ban Ki-moon said, now we have the International Criminal Court, permanent, increasingly powerful. There is no going back. In this new age of accountability, those who commit the worst human crimes will be held responsible, whether they are rank-and-file soldiers or military commanders, whether they are lowly civil servants following orders or top political leaders, they will be held accountable. Thank you for your patience.
Hi, my name is Fatou and I teach Persian here at Washington University in comparative literature. My question is, I understand that things have to be really grave to get to a stage where ICC can interfere, but what about situations like currently in Syria? We just see the figures of people being shot is going above 2,600, I believe. So what is a way to interfere before it becomes bigger and bigger? Thank you.
Maybe I'll take one question at a time. Two? Yeah, I'll just respond. With respect to Syria, unfortunately, Syria is not a state party to the Rome Statute. And undoubtedly, I think the crimes that are being committed in Syria are very serious crimes. I do not see anything different from what has been happening in Libya as to what is happening in Syria currently. In Libya, we have been able to intervene because there was a UN Security Council referral. Because Libya also is not a state party to the Rome Statute, so we could not intervene until we had that resolution referring the case. So these are the two options that are available now for ICC's intervention. Either, already Syria is not a state party, so therefore either a United Nations Security Council referral, or Syria makes a declaration accepting the jurisdiction of the ICC, as has been done in Cote d'Ivoire recently. It's unfortunate. I share that. Yes.
First of all, I appreciate very much the kind of talk that you just gave us about how important the International Criminal Court is in the changing things that are happening in our world. I do think that it's worth mentioning what is important, and that is how the International Criminal Court and the Rome Statute got to be adopted, and the role of the non-governmental organizations. Because it's so apparent from what you've said, so many governments are reluctant to do things that the non-governmental organizations can push them into action. I'd like to know your reaction to that.
Yes, I appreciate your comment. Maybe even what I will say now is an understatement of what the NGOs have done for the ICC to be established. They have played a very, very big role in mobilizing the different governments and leading up to the Rome Conference, where the statute was adopted. In Rome, they were there, fully participating. And they continue to do that. Currently, there is the Coalition for the International Criminal Court, which has now over 2,000 NGOs as members. And they continue to work with states to encourage states. Just in last year and this year, I think we have had about 4 to 5 countries ratifying the Rome Statute. And this is largely as a result of the mobilization that the NGOs have made and continue to make. I think they continue to show the concern that they have, that the institution will be supported, and that also the reason for establishing the ICC in the first place continue to be maintained and supported. So, I mean, as I said, it's even an understatement of what I say about NGOs. The role they have played and continue to play is enormous. I agree.
Hi, my name's Dawn Bensouda. I'm a fellow in bioethics, health disparities, and clinical research. I was wondering if you could comment on how you're able to enforce the rule of law, especially with due process and procedure, where there may be certain areas you have to go into where you're threatened by force.
I'm sorry, I didn't get the last part of that.
How are you able to engage and enforce due process and procedure, particularly in areas where there could be the threat of force present?
That is one of the challenges that we face as an institution. As you know, the ICC, I mentioned, we operate or we investigate in situations of ongoing conflict most of the time. And one of the enormous challenges is even starting the investigations itself. And for some of our investigations, we had to do it without even going to the field. Like in our investigations in Darfur, the government refused to cooperate with the ICC. We reported this to the UN Security Council, as we should have done. And then we had to find ways and means to investigate the atrocities without necessarily being in Darfur itself. That's one of the challenges that we face. But the mandate of the court is such that, you know, we investigate these crimes, but we also have this obligation of the protection of the challenge and the obligation of protecting victims and witnesses. You know, because you cannot expose them. You know, they cannot be made to suffer twice. So all of these things, there is a regime at the ICC currently in which the Office of the Prosecutor, that is the first body that deploys to the field, works with what is known as the Victims and Witnesses Unit. And we have been trying to find strategies and ways in which we utilize to be able to do our investigations into the field. Because at various levels that we come back to the chamber, let's say as Office of the Prosecutor, to maybe request for authorization to investigate, to also request for arrest warrants, to do confirmation of charges. There are different thresholds that we have to satisfy, you know, for the chamber to be able to do what we are asking, whether it's for authorization or whether it's for request for arrest warrants. Yep. Yes.
Thank you for your talk. I'm Kit, and I teach philosophy here. I'm a big fan of the ICC, but I gather one of the most common complaints is the worry about selective prosecution. And so I'd be curious to know what you think about the general concern that such a small proportion of potential defendants are in fact prosecuted, and then the more particular one that disproportionately in the future it looks like Africans will be prosecuted. There's a related worry that those prosecuted going forward are disproportionately going to be Africans.
This is a topic that, or this is a question or a concern that comes up, you know, all the time, and perhaps there are maybe good reasons for the concern. But I always think that if one understands why ICC is in Africa, perhaps that perception will go away, because it's a perception. The presence of ICC in Africa is not by design. You know, it is not designed that ICC is only set up to investigate and prosecute Africans. I think I would have been the first person to resign if that was the case. But that is not the case. And I always say that it saddens me when this is said. And I'm saying this because of this following reason. I think for the first time, African leaders, really, African leaders are taking leadership in international criminal justice. If you look at why we started in Africa, it is because 3 African leaders decided to call in the ICC because they were state referrals. They referred cases to the ICC, requesting the ICC to intervene and investigate and prosecute. That is the Democratic Republic of Congo, that is the Uganda, and Central African Republic. The other 2 African states, which is now Libya and Sudan, was as a result of United Nations Security Council resolution referring the cases to the ICC to investigate and prosecute, which is part of the ICC statute. They can do that under the statute. And they could have established other ad hoc tribunals like they did. But why do that when you have established a permanent international criminal court that has jurisdiction, that can move more efficiently and can handle these cases? So therefore, we are in Libya and in Sudan because of this UN Security Council resolution. And it also did not mean that automatically, if we had the referral from United Nations Security Council, we would just take it and start investigating. No. We assessed the situation on the ground, and we found that, yes, serious crimes are being committed, and that these crimes fall within the jurisdiction of the court, and that is why we decided to also investigate in the Sudan, Darfur, and now in Libya. The other case is the Central African Republic. It's the Kenya. In Kenya, this is the first time that the prosecutor has used his proprietor powers, investigating on his own motion, because this is one of the powers that the ICC prosecutor has under the Rome Statute. But this was not even immediately done. And everything that could be done was done to encourage Kenya to do its own investigations and prosecutions. The prosecutor has made over 8 missions, I believe, to Kenya to talk with the authorities and to convince them and to encourage them to investigate and prosecute. Of course, the cry from the civil society in Kenya was overwhelming for ICC's intervention, because they also believe that it is only the ICC that could be the independent institution to investigate these crimes, because already some of the leaders in Kenya were being tainted, or at least there were allegations that they were involved in the crimes that took place in the post-electoral violence of 2007. So this, with respect to these countries, you can see that ICC's intervention obviously is not by design. And it hasn't stopped there, because just now, after the violence in Cote d'Ivoire, after all these accusations and perceptions that ICC is targeting Africans, Cote d'Ivoire, which is not a state party to the Rome Statute, have decided to request the ICC. They made a declaration accepting the jurisdiction of the ICC, and they have called in the ICC to investigate and prosecute. I mentioned that we just sought authorization, because even with that, even where the prosecutor decides to move, and this I'm just briefly mentioning the checks and balances in the statute, is that the prosecutor does not usually just go start and investigate. We need authorization. And this is by a chamber of 3 judges who will look at the evidence that is placed before them, the information, and decide whether the prosecutor should investigate or prosecute. So, I mean, I have just given you these examples of all our cases to show that, our intervention, our presence in Africa is largely as a result of Africans requesting the ICC to come, and not the ICC going on its own as it wished, and just because it is Africa and it wants to investigate there. And also, if you look at what is happening, we're saying that it's targeting African leaders, but we forget that the hundreds and thousands of victims for these crimes, and we are talking about very serious crimes, are Africans. They're African victims. And if we continue to say that we see what to do, we see how to make these golden exiles for these African leaders or whoever leader is involved, we are forgetting what we all made a resolution to do, and that is to protect the victims. Who speaks for them? I always say that, okay, 100% of the perpetrators are Africans, but also 100% of the victims are Africans. And if I have a choice, I do have a choice, I will stick with the victims.